This is Eyewitness News up close.
Now back to the subway chokehold case. Daniel Penny has now been charged with second-degree manslaughter and could face 15 years in prison if convicted. The Manhattan District Attorney decided to do it without going to a grand jury first. So joining us now to talk about all of it, David Schwartz, a former prosecutor and now a defense attorney. Sir, thank you. Welcome to Up Close.
Thank you.
I want to begin right there because it was our understanding that the case would be presented to a grand jury. What does it tell you that the DA decided to not present it to a grand jury?
It's 6 1/2 dozen or another. It's a pretty normal course of business to not present a case to a grand jury in the very beginning. Usually an arrest is made, like in this case. We have an arrest and there'll be an arraignment today. And then after the arraignment, the DA will present the case to a grand jury. So that's normally how cases work. Where there's this high-profile crime, sometimes the DA will go to the grand jury first, but in the majority of cases, it works exactly the way this is working.
It's my understanding the defendant has an opportunity in a lot of these cases to testify in a grand jury proceeding. Is that true?
Not only does the defendant have an opportunity, the defendant has an absolute right to testify in the grand jury, and that'll be an evaluation that is made. In the far majority of cases, 99.9% of the cases, the defendant never testifies in the grand jury because now you're giving away your case to the grand jury, which can be used later on in the proceedings. But because of the nature of this case, you never know. What I do suspect is that the defendant may proffer some witnesses to the grand jury.
And trying to figure out what happened on board that F train is key. We saw the about 4-minute video with what appeared to be a chokehold already applied to Mr. Neely. The question that a lot of people have is what happened before that? We know there were 5 separate 911 calls, including complaints from the train operator. And at one point, an eyewitness suspected that Mr. Neely had some sort of weapon. We know in the end that was not true. But what do prosecutors need to prove when they're trying to get a conviction in a manslaughter case?
Oh, yeah. So in manslaughter, it's an act of recklessness, right? So it's not an intentional crime, but when you're dealing with a manslaughter in the second degree, and it's a reckless act. So the question becomes, was this act reasonable? Was this act taken where there was a justifiable consequence involved, a foreseeable consequence where a death may occur due to this act? And was that consequence ignored by the defendant, in this case, Penny? So all those factors have to be looked at. But like you prefaced the question, you have to look at all the facts and circumstances. There can't be a rush to judgment just based on a video alone. You cannot do that, and that's why the DA has worked through this investigation methodically.
And that's the thing, right? Everybody's forming an opinion, particularly because we have video of at least partial evidence in the case. I only have about 30 seconds left, but in that video that we see with the chokehold, or at least it appeared to be a chokehold being applied to Mr. Neely, it sounds like Mr. Penny is saying, call 911. How much of a factor will that play in the case?
Right. You have to look at all the facts and circumstances, but there'll be an affirmative defense here of justification, of self-defense. And the question becomes, did the chokehold go on for too long? 6 minutes is a very long time. So the question becomes, on the self-defense of the affirmative defense of self-defense, you know, what was that defense enough? Was it justified? And did the defendant assert as much physicality as it took to withstand the situation? And that's something that a jury will have to look at.
Only got about 10 seconds left. How tough of a case will this be for prosecutors? How likely is it that they're going to win this thing?
I don't know, but it's a very tough case. There's arguments on both sides, and we'll have to see what the jury does or if there'll be a plea negotiation in this case.
David Schwartz, always great to get your perspective. We appreciate it.
Great.